Are you wondering how to transfer your bank accounts into your shiny new living trust, avoiding probate and complications for your heirs? Today, we're diving into the crucial steps to make this happen. Hi, I'm estate planning attorney Mike Smtih with Smith Barid LLC, and I'm one half of the estate planning guys. So the first thing we need to talk about is what's a trust. So I'm going to just briefly explain a trust because hopefully if you're worried about transferring accounts into the trust, you've already got one. But a living trust is essentially a bucket into which you put your assets. And as long as you're alive and you're competent, so you have your wits about you, then you hold the handle to the bucket and you can do anything you want to with the assets, the stuff in the trust bucket. So you can take things in and out, you can transfer it to other people, you could pledge it for a loan, you could sell it, you can do anything you want to do with the assets that are in the bucket, just like you could when you own them yourself outright. But now we have this trust bucket that owns these assets. And the huge benefit to having your assets owned by this trust bucket is that it really simplifies things. If you went through a period of incapacity, so let's say that you suffer from dementia or you have a stroke and you cannot manage your own affairs anymore, then the person that you've selected will take over the bucket from you and they'll manage the assets in the bucket for your benefit as long as you're still alive. And the alternative to that, if you don't have a trust in place, is that your family may be faced with going to probate court and having you declared incompetent by the court. It's a lengthy process. It can be very traumatic and expensive for the family. So a trust is a great way to avoid that sort of circumstance for you and your family. Other thing about a living trust is that when you die, if you don't have a trust, so if you have a will or you have no plan at all, then your estate will go through a probate process. That is a court process wherein someone is appointed to be in charge of your estate. So an executor, administrator, personal representative, different names are used to describe that role. And that person is responsible for wrapping everything up, making the distributions out of your estate, etc. But before they can do that, they have to go through this process of probate and be appointed by the court and given the authority to take over and manage your assets. With a living trust, we don't have to go through that court process. The person that you've chosen, the successor trustee, just takes the handle of the bucket after you've passed away and takes care of distributing the assets out of the trust pursuant to the instructions you've left. So your trust will say, here's how I want you to distribute it, here's how I want it divided up among my family, and here are instructions for how you're going to do that, or I want this specific asset to go to my church or my university or whatever charity. But those instructions are all in the trust, and the successor trustee just follows those instructions and distributes your assets out of your estate, out of your trust, without having to go through that probate process. So those are two huge benefits of having a living trust. It also avoids multiple probates if you own property in multiple states. So a living trust is a great way to handle your estate planning. So that's what a trust is. Now, why is including your bank accounts in your trust such an essential thing? A lot of times people say, well, gosh, I have a joint account with my wife, so if something happens to me, it won't be any problem. And that might be the case. But if something happens to both of you, so let's say, for example, you're involved in a car wreck and you're left in a situation where you can't take care of things for a while. If the bank account is in a trust, then the trustee can just take over and manage that bank account, pay the bills, make sure everything's taken care of. And then when you're better, you can step right back in as the trustee and take control of things again. But without it being in that trust, it may be a situation where we have to file that conservatorship proceeding in probate court to get someone in place to take care of things for you. So having the bank accounts in your trust is vitally important for that reason. And I want to address one other thing that I hear frequently from some of my elderly clients. They say, well, can I just put my son or daughter on my bank account with me and then they can take care of things if I'm not able to? That does in fact work. So you could put your son or daughter on your bank account with you and then they could operate that bank account if something happens to you. However, there are some problems with that. And it's kind of like, you just see the tip of the iceberg, but not all the stuff underneath. And it's the stuff underneath that could reach out and grab you, get you, if you will. So let's talk about what those potential issues are with putting your son or daughter on your bank accounts. The first thing is that by adding them as a co-owner on the account, if they have a financial issue, if they have a creditor come after them, or they are sued for some reason, then your assets potentially are exposed to that creditor. So if your daughter, for example, runs up a lot of credit card debt and she has a financial problem as a result of that and she gets sued and they obtain a judgment against her, then your bank account is subject to that judgment because her name's on it. The second issue is a gifting issue, and the way that this can be a problem is if you have your daughter named on your bank account, when you die, that will become her account. She's a joint owner on the account, so when you pass away, it's going to transfer automatically to her. And let's say that your intention was that she would split that account in half and give half of it to her brother. And then let's assume that the account has, let's say, $100,000 in it when you pass away. When your daughter takes ownership of that account, when you die, it becomes hers, right? And then she's going to give $50,000 to your son because that's what you wanted to happen. The problem is that that is considered a gift and she will be required to file a gift tax return with the IRS. And while she does have a gift tax exemption, you're going to use up part of her lifetime exemption from gift and estate tax when she makes that transfer to her brother. So there can be unintended consequences to the idea of just adding your son or daughter to your bank account. So it's really the best thing to do is to have a living trust and to transfer the bank accounts into your living trust. Now, let's talk about the process of transferring your bank accounts into your living trust. And let me say here that every bank or institution has their own rules about how you do this. And so things can vary a bit between different banks. So I'm going to talk in general terms about how it works most of the time. And your situation, maybe your specific situation, may be slightly different from what I'm talking about. The first thing you want to do is just review your trust agreement, make sure that everything is still set up like you wanted it. If it's been a while since you set up your trust, you may want to look at it and make sure that the people that you've named as successor trustees are people that you still want filling those roles, that, you know, if you set things up to split up among your kids, that's still what you want to happen. So just take a minute, review the trust agreement and make sure that it still matches what you want to happen. And the next thing is that you're going to want to gather any necessary information. So the bank is going to need, obviously, your account details. So you're going to have your account number handy and the name on the account, that sort of thing. And then they're also going to need some confirmation of your trust. Now, most states have created something called a certificate of trust, a certification of trust, an affidavit of trust. Those are all sort of the same thing. And it's basically an affidavit that says, hey, I created this trust on this date. I am the grantor of the trust, the person that set it up. And the trust is still valid under state law. And that document is going to be something that the bank's going to need to see because they need to verify that the trust is actually in existence before they move your accounts into the trust. Sometimes banks will ask for a complete copy of the trust. In most cases, they do not need a complete copy of the trust. Now, as a practical matter, you may not want to fight with them about it. You know, you trust your bank with confidential information, so you may say, well, I don't want to bother with fighting over whether they get a copy of the whole trust or not, so I'm just going to give it to them. That's your choice to make. In most states, the certificate of trust is sufficient evidence for the bank to be able to open that account or transfer that account into the trust. It definitely is in Georgia, and they can't require you to give them a copy of the trust. But as I said, as a practical matter, you might not want to fight with the bank about it. You may say, oh, well, here's a copy of the trust. I have had the experience in the past of a client giving a copy of the trust to the bank, and then the bank sending a copy of that on to a real estate attorney who was doing a closing for them without their authorization, without their specific authorization. So it can be a problem sometimes that a bank might disclose information you don't want them to. So you have to decide for yourself whether you're going to argue with the bank about providing a complete copy of the trust or not. At the very least, they're going to need a copy of that certification of trust or affidavit of trust, it might be called. And you're going to gather all that information together, and then you've got choices. You can either go into the bank, or sometimes they will have forms that you can download from the website. A lot of times you're going to need to go into the bank and meet with the customer service person, but the more organized you are, the quicker and easier that's going to go. Now, before you go into the bank, I would contact the bank. So call your branch or get on their website, and what you want to tell the person on the other end of the line, or what you want to search for on the website, is I've just set up a living trust. I need to transfer my accounts into my living trust. And there are forms that the bank will have called a change of ownership form. And that will change who the owner of the account is. And what you want to do is to change that account owner from your personal name into your trust name. And your certification of trust should have the name of the trust on it. If not, then it'll be in your trust document. But the formal name of the trust is what you want to use. So it might be something like the Mike Smtih Living Trust dated January 1st, 1901. That would, be sufficient for the bank's purposes. And then you're going to sign that as the owner of the account. And they may have you sign as the trustee as well. And typically, if you go into the bank customer service person is going to be able to assist you with filling out the form and then signing it. That's why I suggest, if you can, to go into the branch to take care of this business. But you can download the forms and just look at ownership. They'll usually have a section for trust ownership, and you would put the trust name in there and who the trustees are, and then there are going to be spots for you to sign it. Then you're going to return this documentation to the bank. If you're in the office at the bank, if you're in the branch, then they'll take care of that paperwork there. They'll make the changes. If you're going to mail it in or email, if there's an online form you're filling out, that's great. It's more convenient than going in, but you need to verify that the transfer has actually been made. And the way you're going to do that is when you get your next statement, you're going to take a look at it. And if it has been properly transferred into your trust, then it's going to have something in the name that indicates that it's in your trust, or have your name as trustee. There will be some indication on the statement that the transfer has been made. Or you can ask the bank for a confirmation letter. So you can ask them for a letter on their letterhead that confirms that the account has in fact been transferred into the trust. It's very important that you confirm that it's done, because if it's not properly transferred into the trust, then we really haven't accomplished anything. So you're going to want to get confirmation from the bank, either from that statement that shows that it's in your living trust, or some sort of separate letter that they send you to confirm that it's taken care of. Now, some common mistakes: forgetting to update beneficiary designations. Usually with a checking account or savings account, you're not going to have a beneficiary designation on it, but let's say a life insurance policy, other types of assets, they have beneficiary designations on them. And you've got two choices there. One is if you want your trust to control the distribution of that asset. So let's take a life insurance policy. If you want your trust to control the distribution of the death benefit of the life insurance policy, then you need to make sure that the beneficiary designation names the trust as the beneficiary of the life insurance policy. And so then what happens when you die is the trustee files a claim with the insurance company, and the insurance company cuts a check to the trust. That's what you're going to want to happen if you have minor children, because after all, you don't want that life insurance policy to pay out into your estate or to them and then have another mess to go through. You want the trust to control the distribution of that. So that's an example of the type of beneficiary designations that you need to make sure are updated now that you've set this trust up. And then the other thing, I've already mentioned it once already, but just confirm that the account has in fact been transferred into the trust. So confirm with the bank that the bank account has been successfully transferred into the trust. Now, if ensuring your estate is managed smoothly and according to your wishes is a priority for you, I invite you to get in touch with us at Smtih Barid. We specialize in making estate planning straightforward and secure. Visit our website or use the link in the description to book a consultation. And remember, planning today can bring peace of mind tomorrow. If you're interested in learning more about estate planning, subscribe to our channel, The Estate Planning Guys. It's packed with valuable information on estate planning that you won't want to miss. I'll see you in the next video.